Welcome, welcome, welcome. We are live. This session, we're going to be talking about affidavits and how to apply them in a manner that is what is called effectuating a document or perfecting it. So, before we get into bona fide the document, we want to know what the document is for and how it's used, what an affidavit is to begin with, because a lot of people call things affidavits of estoppel just because they wrote something on paper that they believe and not understanding that it can be contested. So we're going to discuss writ of mandamus since we sovereigns.
Welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll. And the question we have this week is, what do you do when a trial court refuses to carry out its duties under the law? Say, like the trial court, for whatever reason, is refusing to conduct a hearing, or the trial court has not issued a ruling for, it's been a year, for example, something, outrageous. What's your remedy for that? Well, what your remedy is to invoke the original jurisdiction in the appellate court, in the district court of appeal, for example, when you're coming from a circuit court, and you would file an extraordinary writ. The writ is a writ of mandamus. So it's important to understand exactly how mandamus operates, when to use it, how to effectively use a petition for writ of mandamus. It's because you have all sorts of problems, all sorts of issues can come up in a case in the trial court at any time. But all is not lost. So when you have non-standard issues and particular issues, you can challenge them at the appellate level. It's not necessarily an appeal. They don't call it appeals. You don't have briefs, but it's an extraordinary writ. So here we're going to talk about mandamus. And what does that mean? All right. Mandamus is a common law remedy, right? It's used to enforce an established legal right by compelling a public officer or an agency to perform a duty required by law. All right. So like other original proceedings, there's prohibitions, cert. We've addressed some in the past. We'll address some in the future. You're going to follow Rule of Appellate Procedure 9.100. That lays out a lot of the procedures that you'll need to follow, and we'll go over that. But when talking about mandamus, one of the fundamental principles for issuance of a writ is that the legal duty that you're talking about of a judge, a public officer, a public agency, has to be a ministerial duty. It can't be a discretionary ruling with the entity. Now, a duty or an act is defined as ministerial, quote, when there is no room for the exercise of jurisdiction and the performance being required is directed by law. All right, so mandamus has to relate to a ministerial duty that the underlying agency or court is simply not doing, and they should be doing it. So you would do a petition for mandamus. If there is another adequate remedy, you need to use that. But if there is no adequate remedy, then you use the extraordinary writ of mandamus. All right. Now, and administrative law, of course, and this is really what that requirement is going to, the doctrine, you have to exhaust your administrative remedies, of course, before going to court. So that's when that principle will kick in. Private rights between individuals, legal obligations, have no place in mandamus. Okay, that's just straight appeal. You have to deal with that through your regular course of appeals, of a standard appeal, for the most part, depending on the individuals. And then that's another topic when you deal with the CEOs and certain corporations. Now, what are some examples? All right, well, I gave you a couple in the beginning. the court is refusing to hold a hearing that, hey, your client, are perfectly entitled to, but the court refuses to do. That's an example. One of the most common uses is the filing of a petition to force a public official to issue a license or a permit. So let's say your petitioner, you meet all the qualifications for issuance of a building permit. The appropriate government official has no discretion to deny the permit. So if it's a ministerial duty to issue that permit, mandamus is often used for that purpose. And now, another use for mandamus is to test the correctness of an order determining that a court lacks jurisdiction. So you can have where the trial court dismisses a case claiming it doesn't have jurisdiction, but you're saying, hey, I think I'm reading the law this way that, yeah, you do have jurisdiction. So you can do a petition for mandamus to challenge that. Other examples, you can compel a trial judge in a criminal case to grant a preliminary hearing to an accused. And we'll be putting cites also as part of our journal entries and on the website that supports the mandamus petition. You can also do a petition for mandamus to a trial judge to submit to a jury the issues that are triable by tribal as a right by jury. You can also compel a trial judge to enforce a foreign state child custody decree, compel a trial judge to exercise jurisdiction, as we stated, and compel a district court of appeal to reinstate an erroneously dismissed appeal. So there are lots of examples, and we'll try to cite some of them again with this topic. Now, remember, the trial judge is not to be named as a respondent in the caption of a petition for a writ of mandamus. Now, that's important. You do that, you're going to get a kickback. So even if you're directing it to a trial judge to enforce a ministerial duty, the trial judge does not get named. Now, you can include it. You will include it in the body of the petition, and you'll also send the judge or the underlying agency a copy. And usually how it works is any of the parties to the proceeding that are opposing your petition, they can go ahead and respond, all right? And the judge can, but 99.9%, they're not going to get involved in that. But they certainly have no duty to respond to your petition. So that's just a very key point, because a lot of times people will include that, and it's not appropriate to do, so you want to avoid that. So initiating review, again, I refer you to Florida Rule of Appellate Procedure 9.100.
What she say?
Stated, and compel a district court of appeal to reinstate an erroneously dismissed appeal. So there are lots of examples, and we'll try to cite some of them again with this topic. Now, remember, the trial judge is not to be named.
Now, you got to keep in mind that this lady worked for somebody, and she seemed to be, judging from her other videos that we watched, she seemed to be very knowledgeable about the law, but she's being very hush-mouthed too. Make sure she don't say something contradictory to their policy, um, disclosing their practices and schemes in a way that is not where she create a conflict of interest with her job. She doesn't really have the freedom to say to speak the truth. She can um, mention the truth, but she can't speak the truth. She's censored by conflict of interest, and so she has to avoid speaking about some things. That's like she's not going into the different ways that a writ of mandamus can be used because of how powerful it is, and she doesn't want to tell you all the secrets of that particular process, because she's trying to steer you away from doing that. And because what it does is it makes, if you if you send a document directly to the judge, she said it may get kicked back. Notice she said it may get kicked back. And so she's not stating for certain that they're going to kick it back. What she's actually trying to do is not keep you from getting your documents from being kicked back. What she's trying to do is steer you away from doing that because it puts a strain on the judge to, um, especially if you send it by certified mail or documented at the court clerk office, that you address that directly to the judge. That is considered an ex parte um, assignment. It's an ex parte um, communication. And so, in a way, I'm a little angry with her for steering you people away from that because people need to know the power of ex parte and not just the power of it, but to know that they can speak to the judge pro se ex parte and not think only the lawyers can speak to the judge ex parte. That means, uh, you know, sidebar, so to speak, and it's to the side, it's off to the side, it's private. It's not on the record, but it's on the record. Whatever you discuss is off the records, but it's probably discussing things that whether you want it on, whether you want it to be on the record, or whether it's okay to put it on the record, or what kind of harm would you cause, or your opponent could cause if you're filing a motion to suppress evidence. You'd be discussing what kind of harm uh, it could cause with your opponent putting certain information out and so forth like that. So it's very powerful to know that you can talk to the judge, and so they not really wanting a lot of people to know that.
To respond in the caption of a petition for a writ of mandamus. Now that's important. You do that, you're going to get a kickback. So even if you're directing it to a trial judge to enforce a ministerial duty, the trial judge does not get named. Now you can include it. You will include it in the body of the petition, and you'll also send the judge or the underlying agency a copy. And usually how it works is any of the parties to the proceeding that are opposing your petition, they can go ahead and respond, all right? And the judge can, but 99.9%, they're not going to get involved in that. And they certainly have no duty to respond to your petition. So that's just a very key point because a lot of times people will include that, and it's not appropriate to do, so you want to avoid that. So initiating review, again, I refer you to Florida Rule of Appellate Procedure 9.100. It tells you, it's an original proceeding, so you don't need to file anything in the lower court like you do in a regular appeal.
Now, this is a part of the fraud. Now, she paused when she said that because she knew that she was speaking something in dishonor. I could tell by her body language. She paused when she said that because she knew she was speaking in dishonor. So she was trying to make sure she could say that where if somebody called her to the carpet on it for telling a lie, um, or helping to perpetuate a color of law, and somebody call her to the carpet on it, then she can easily backpedal out of that and just say it was a generalization, that each judiciary do not have any type of obligation to do what you say, um, or to adhere to your requests, um, because of the fact that you don't have to ask them to do nothing. She she purposely omitting that part, because the reason why they don't have to do what you ask them, because you are asking them. It is a request for them to get involved in your situation. But you also can just over yourself there, go past them. It can be like, okay, well, if you this smart to write this type of a writ of jurisdiction, then write a writ of certiorari, whatever I think it is called. It's when you ask for the higher courts to um, get involved, because um, someone is operating irregular in their estate, in their court system. And so you choose another system to take up your case. You can take it straight to the Supreme Court. A lot of things is federal, and people don't even know what aspect of it is for federal, because they think it's something small in their own mind, and they just want the lower courts to deal with it. Okay? Well, the lower courts may decide that it's that small where they don't even have to follow the Constitution. And that's where you left yourself vulnerable to somebody else's sovereign authority. And so she's right to say that they do not have to accept your request. But let's be clear. That's just like if you come to me with your problem and you come on my channel and you ask me, say, Candy, well, I'm having this problem with this other person on this other channel, and the other person may say, well, um, why you asking Candy to mediate this situation between me and you? Uh, uh, I don't think she don't have no authority to tell us what to do on our channels. We need to go to YouTube and settle this matter and ask them. Or some people don't even think to go to the organization. They may be thinking to go outside the organization. Let's take this to court. I done seen some people arguing back and forth on YouTube and literally took their cases to court. And so, when you do that, though, that shows what immaturity, because that means that y'all wasn't even adult enough to be able to handle that between yourself, first of all. And second of all, when you do present yourself in that manner and talking straight to the judge, you better be talking on his level. Since you come at him like that, you need to be talking on his level. Otherwise, you need to get you a lawyer to represent you, because you're stupid. And it's the only wise thing for you to do is get a lawyer. Or if it's just a ticket, just pay up. And why you bucking the system anyway? You ran the motherfucking red light. I'm saying, for example, I see a lot of cases of these so-called sovereigns fighting a case, about running a red light. Okay, I can understand fighting a case about not having an inspection sticker or insurance because you got insurance and you don't need no damn inspection sticker. Is the motherfucker driving? Um, and another thing is they releasing all kind of toxins in the air, not near way in comparison to you and your one little vehicle. So on that, I can understand a person just wanting to learn how to defend themselves, going into court, and learning how to articulate themselves in defense in a the craft of court, learning in the craft because court is a craft. It's a industry of commerce. It's like being a pilot. You can't just jump behind no wheel of no airplane. You got to have a pilot license. Otherwise, you got to get your ass in the back and be a passenger. You got to ride with somebody got some goddamn license. Get you a lawyer. And Yusef is very knowledgeable on how telling you how to speak to your lawyer in order to get them to cooperate to your best benefit. And I, on top of that, would suggest that you send your own documents in that you asking a lawyer to send in. I'd be done sent them in myself and then give them to the lawyer just to test him to see if he gonna do his damn job. And then if he don't do his damn job, then now I got him on ineffective counsel. That's how you work the system. That's automatic mistrial, ineffective counsel. And you file a motion for that. Soon as they do anything you don't like, you file a motion for ineffective counsel. And you learning how to file motions and stuff like that. If you gon' file motions, then please understand you have to conform to their rules. Sovereigns don't really file motions. We file petitions and complaints and responses, and we are called relators. We relay information. We'll report your ass to the IRS and things like that, which you think court don't have nothing to do with that when they gave you a 1099, when they gave you your ticket. Uh-oh, I'm dropping jewels. Where my little gift pack at? I'm dropping jewels. Hold on. I'm dropping jewels. Hold on. Let me get my little gift pack I made for y'all. Hold on. I'm dropping jewels right quick. Hold on. There it go right there. Oh yeah. There it go right there. I'm dropping jewels for y'all. Here it is. Dropping jewels. Yeah, drop a little jewels on y'all right quick. Cause y'all ain't even understanding. It's get real to get real, and they get real raw.
Or court, like you do in a regular appeal. You file notice of appeal first in the trial court, and then that goes up to the appellate court. But
we gonna run this shit back because I want to hear that to that 1980s disco ass music she got on there. We go fast forward past that. We already gave her her
Carol. And the question we have this week is, what do you do when a trial court refuses to carry out its duties under the law? Say, like the trial court, for whatever reason, is refusing to conduct a hearing, or the trial court has not issued a ruling for, it's been a year, for example, something, outrageous. What's your remedy for that? Well, what your remedy is to invoke the original jurisdiction in the appellate.
What you heard what she said? What is your remedy? Everybody know what a remedy is? If you don't know what a remedy is, type remedy in the chat. What she said? Invoke. I can't spell. Invoke the original jurisdiction. You know that? You know what that is? Huh? Everybody, son of a gun, that original jurisdiction. Bad son of a gun, you know what I'm saying? Original. You got to invoke it. Hey! Bad son of a gun. Say that again, baby. Say that again for us. We need to hear it again. For the slow people in the back.
What do you do when a trial court refuses to carry out its duties under the law? Say, like the trial court, for whatever reason, is refusing to conduct a hearing, or the trial court has not issued a ruling for, it's been a year, for example, something, outrageous. What's your remedy for that? Well, what your remedy is to invoke the original jurisdiction in the appellate court, in the district court of appeal for.
That's all we want. That's all we want right now. Is to invoke the original jurisdiction. We just wanted a snapshot of that, baby. Appreciate you. And y'all watch her whole video, get all the goodies she got over there. I was watching another video of hers earlier, I believe. No, we was watching about the affidavits, all right? And we need to check back in the comments and see if we can find some more about affidavits. But let's see what she got to say about it. We didn't heard that bullshit before. Okay.
Writ of certiorari is one of several extraordinary writs, which means you don't technically call it an appeal, but it is a proceeding. It's an extraordinary writ proceeding that you bring to the appellate court under very limited circumstances, and we're going to discuss that today. So you'll know the answer to the question on what is the petition for writ of certiorari all about. When can I use it? What's the standard of review for a petition for writ of certiorari? What are my chances of prevailing on that, and what are the procedural technicalities for bringing that in my case? And the petition for cert, so that you know you can use that, you still have a 30-day rule, which is 30 days after rendition of the order that you seek to review. And you'll usually do a petition for writ of certiorari during the pendency of litigation in the trial court. It can be pre-trial, because normally in your standard appeal, as you know, you have to wait for a final judgment, and then you can appeal that. There are also, and I know I'm giving you some basics, I'm sure you already know, there are also certain defined non-final orders that are appropriate for a non-final appeal, and they're laid out in the Florida Rules of Appellate Procedure, and they're very specific, very narrow, and you have a little bit different timelines on prep of any kind of record there. But the petition for writ of certiorari is a very unique creature. It has its own rules in the Florida Rules of Appellate Procedure. The definition, okay, a writ of certiorari is used to remedy the trial court's action that exceeds its authority or departs from the essential requirements of law, and there's no alternative legal remedy. So you're going to file a petition for writ of certiorari if you've got an order that is a really bad order, and it's not the type of order that can be remedied by a subsequent final appeal in the case. Okay, that's very, very important. And number two, it has to result in irreparable harm to your client. A lot of cases, we'll talk a little bit about that, defining what is irreparable harm. Okay. But those are, and it's a very strict standard, much stricter than review, on a normal, on an appeal. But you've got to meet those requirements. And again, the timing, you file it 30 days after rendition of the order to be reviewed, and you're not filing a notice, right? Not a notice of appeal. You're filing a brief, although it's a petition, so don't call it a brief. And it could be, 30 pages, 40 pages, 10 pages, but that's your argument. You're going to lay out the facts. And there are forms you can follow in all the books, but you're going to put your statement of jurisdiction, your statement of the key facts, and you're going to put your argument. You're going to have to convince the appellate court how this order that you're appealing does depart from essential requirements of law, is causing irreparable injury to your client, and it can't be remedied by a subsequent appeal. Also, the record, you have to do an appendix, okay? So the clerk's not going to prepare your record for that. So when you do, you file it within that 30 days, you're also going to file an appendix that's going to have the key record documents that support your argument. So you're going to have everything done fast. And if the appellate court believes that you have made out a prima facie case, so on the surface looks like, hey, they think you're right, they'll issue an order to show cause, and then they'll set up a schedule for when a response will be due from the other side and when a reply will be due. And then they'll render their decision, and they can grant the writ, or they can, of course, deny the writ. And a couple little things to keep in mind, that if a party improperly files a notice of appeal instead of a petition for cert review, the appellate court shall treat the cause as if the proper remedy had been sought. And that's Florida Rule of Appellate Procedure 9.040, parent C. And in many cases on that. And standard of review, again, I think we talked about, the departure from essential requirements of law, got to be a material injury. And you can't be trying to use it to try to circumvent the Rule 9.130, which talks about the non-final orders that are reviewable. Then a little something too, I'll make it more detailed. There's a petition for cert process. Now I'm talking about, when we're talking about petition for cert, you're normally talking about going up from your circuit court, traditional circuit court, up to one of the DCAs, District Courts of Appeal. But you also have appellate review that a circuit court does to county court decisions, to administrative agencies. And that's a first instance. They have the circuit court, and those particular kind of cases, they use the circuit court as the appellate court of the first instance. You can then take a petition for cert to the district court to review the circuit court's decision. But again, very different and a much more limited standard of review there. and and just because you disagree with what the circuit court did in its appellate review capacity, that's not enough. All right, then you're going to there's going to have to be a denial of procedural due process, departure from essential requirements in such a way as to cause a true miscarriage of justice. And you have to look, the cases, because that is very, very narrowly construed. And
We love sharing around here. That's all we did. We did a little sharing. All right, we've been on here over 30 minutes, and we're not getting too many responses. Oh, we're not getting any responses because our chat wasn't open. My bad. Hey, what's going on? My apologies. Hey, two fans, what's going on?